Good evening, everybody. I hope you are all doing well. This is Jonathan Ginsburg, and welcome to another live stream. I hope, again, everybody is comfortable, the weather is good where you are, and that you're starting to enjoy the spring weather wherever you are. Again, I'm in Atlanta, and we had hit about 80 today. Very, very nice. So, again, I hope it's nice for you. I had a good week. Got 6 decisions, won 5 out of 6. My clients did. I mean, obviously, they did the hard work, but it's always nice to get a lot of favorable decisions, which is, good for the team, for everybody in my office. And so what I do is when we get a favorable decision, I send a copy of it to my client, but I also send a copy to all my staff people, and they are able to let the client know how happy they are, because again, we all do this as a team. So anyway, good week on that regard. So happy about that. All right, let's kind of jump into the question. Oh, and by the way, I'm going to have, last week, I may have mentioned this, the NOSCR convention was held in Washington, D.C. And NOSCR is the National Organization of Social Security Claimants Representatives. I did not go this year. I went last year. In fact, that was my first live stream in Nashville. I did not go, just some family issues and medical issues I've talked about a little bit. Couldn't go, but I've got a couple of people who did go who are going to come on next couple of weeks and report what they heard, what they are seeing as far as the future of Social Security and kind of what changes we can expect. So stay tuned for that. I've had one person firmed up for, I think, the middle of the month, and I'm going to try to get somebody else coming in as well. So let's hit the comments right now. We got a lot of comments already here. Okay, so G.I. Jose Joe sent out his 3-page pre-hearing brief. How much is too little? That's about right. I mean, when I do a brief, it's typically going to be anywhere from 3 to 5 pages, 3 pages. Look, a brief is supposed to be brief. So the shorter it is, the better if you have the highlights. And the key is to identify why you believe that you are disabled, or in my case, why I believe my client is disabled. I'll give some background information like the date of application, date last insured, but really the gist of it is medically why the person would be disabled, and judges like it because it really narrows the issue. I've been kind of working on kind of a format for mine. I keep trying to tweak it, but that's the gist of it is, why you are disabled. So that is, that's about the right length, Joe. And he says, experiencing unreasonable accommodations, undue hardship. When you say unreasonable accommodations, I'm assuming you mean at a job that the accommodation that would have to be made is not something that you're going to see in a job. And, just so you know, when we talk about accommodations, that's kind of a legal term that, the ADA, Americans with Disability Act, requires that employers provide some sort of a reasonable accommodation to people who are disabled. And if you have an accommodated job, by definition, that is not competitive employment. In other words, let's say that you have visual issues and your employer buys you a 35-inch monitor, or, lets you work with really, really large type that slows you down. That is an accommodation that would probably not be, given to anybody otherwise. Or let's say you have a special orthopedic seat. So by definition, an accommodated job is not competitive. Therefore, it wouldn't count. If, in other words, if the vocational witness said, this person, let's say Joe, he could do this job if the accommodations were made, by definition, that means that the job is not competitive. So that works in your favor. As far as undue hardship, I'm not sure what you mean by that. Undue hardship, again, maybe you're talking about accommodations, but again, anything that's out of the normal, because the way they look at it is, if you're looking, if vocational witnesses are looking at employment, they're going to ask, is there a job in the competitive marketplace that a hypothetical person could do? Not accommodated, not special considerations, not, given any sort of unusual accommodation. So if that is the limit, if that's your limit, you could do the job, but you would need, let's say, the right to go to the bathroom 5 times an hour. That is not competitive employment, and you would be found disabled. Okay, so hopefully that's the case for you. Shub, DDS called and asked if I had surgery on my knees. I did have one scheduled, but lost health and coverage. Will that affect your claim? They said they're almost finished with your decision. They'll ask treatments you've had for stage 4 osteoarthritis. Basically, surgery is the only treatment. So to answer your question, under Social Security law, um, if you choose not to have surgery, or you don't have it because of insurance issues, that will not be held against you. There's actually a ruling about this. And the ruling basically says that if you have a reasonable concern about undergoing surgery, going under anesthetic would be one thing, or concern about a poor result. Those are the type of things that Social Security cannot say, well, we're not going to approve you because you wouldn't undergo a 3-level fusion. So any procedure, even a minor procedure, if you have a reasonable fear, that would be grounds to deny, or that would be something that they would not hold it against you if you chose not to do it. And certainly, loss of insurance coverage would not be your fault. They would not hold that against you. Now, the question is, if let's say that you were ordered to go undergo physical therapy, you chose not to do that. That's a little tougher call because generally physical therapy is not invasive. And while it may be uncomfortable, it is a reasonable thing to expect somebody to do with orthopedic problems. So I don't think you could refuse physical therapy unless there was some really unusual circumstance. But any kind of a surgical procedure involving invasive surgery where they're cutting on you or injecting you with something, even epidurals have negative effects. I mean, if you have to sign a release for it that says this could kill you or leave you paralyzed, then that's not going to be held against you. And the fact that they said they're almost, they want to know about your treatment, they're trying to update the file to see you've got stage 4 osteoarthritis. So they want to see what the doctors are saying. And if the only possible option to treat it is, long-term pain management or surgery, you're a surgical candidate, that works in your favor. Now, again, it's going to make it a lot easier if you're over 50. If you're 35 years old, that's going to be hard. But if you're 50 or 55, and you've got, a level of arthritis that can only be treated with surgery or, narcotic pain medications, that would be, generally speaking, disabling. Blue Z says, can you advise me on what the auxiliary benefit phone call is like for kids to receive SSDI benefits after you are approved? I think that they really just want to confirm the ages of the children. You might have to provide birth certificates. They're going to want to know that they're dependents of you, not somebody else. They're not getting any other type of Social Security benefit. And that's pretty much it. I mean, honestly, I've never really been in one of those interviews, but most of my clients with auxiliaries, and by the way, congratulations on the win. It's usually not an issue. And again, if they were getting, disabled adult child benefits, that could be potentially an issue. If they were living with a different parent, another custodial parent, that could be a different issue. If they were not, if they were, your children, but they were not either biological or they were not adopted, you didn't have any legal grounds to claim them, that might be a different story. But otherwise, I think it's just a matter of confirming that they're your children, that birth certificates, that they're not receiving other benefits, and of course they want to confirm the age, things like that. But that's pretty much all. I don't think it's a really big deal. And so that's, again, I think that's the answer there. All right, good question. Chubb asks about, does SSA inform long-term disability insurance of their decision? The answer is no. Social Security decisions are private. They will inform you. The insurance company will expect you to inform them. And what happens is, I know because I've got a number of cases where my client's receiving long-term disability. And so what happens is the insurance company will write me or email me. Typically, they send me a letter every 5 or 6 months asking for a status update. My client, of course, has authorized me to release that. And they expect you to notify them when you get a decision, because you've got to repay them for any month where you're getting both long-term disability and Social Security, assuming it's a company policy. The one caveat is there are some individual policies that you buy privately that do not have the offset provision. But if it's a company employer-provided policy, it almost certainly has an offset provision, which means that the insurance company gets to benefit from your collecting Social Security. In fact, this is an issue that pops up sometimes. I'll talk to clients and they're getting long-term disability, and the insurance company, as part of the policy, requires them to file for Social Security. And so my client will ask me, what benefit does it give me? I'm not going to get any extra money out of it, but it's required. And should I just use their non-attorney rep or their person to do it? My answer is insurance companies are notorious for trying to cut people off. So if you get on disability, Social Security disability, and they cut you off, you now have a backup to continue receiving benefits. You also will be eligible for Medicare. You also get cost of living increases that do not benefit the insurance company. And there's insurance companies only going to my understanding, is only going to be able to reduce what they pay you by the primary benefit, not the cost of living. So there are benefits to it. The biggest one is, at least in my opinion, the insurance company, because they make you pay back what you've received, but they don't make you pay back the attorney's fees. So in fact, whether you have me do it or whether you have one of their non-attorney rep companies do it, no cost to you. Because if I do it, then basically you pay them back all your past due benefits less the attorney's fee. So you don't pay them back the attorney's fee part. So in fact, they're picking up my fee. So it's actually, in that regard, it's a win-win for everybody. Like I said, it doesn't put more cash in your pocket, but it is beneficial for you if the insurance company should play games later on. All right. St. Louis Grand has a couple of questions. What's your turnaround time you're seeing for vets at 100%? And that's all. Let's start with that question. If you're 100% VA rated vet, you'll be put to the front of the line. That will speed things up. Right now, cases are taking anywhere from 18 to 36 months. I mean, some places it's 3 years. I think 100% VA will probably knock a year off of that. Maybe the system is still pretty broken, but it'll get you faster. I would say probably by a third. I'll just leave it at that. But that's just, it depends on where. That's a very general statement. Is there ever a situation where the VE, vocational expert, says there are no jobs the claimant can work at the very start of their contribution to the hearing? Generally not. I mean, the VE is not going to testify. So he says, so even if before the judge says the person's limited, could the VE say from the start? No, because the judge is going to pose questions to the VE. The VE is only there to answer questions for the judge. So, if the judge feels like the case is compelling, he might, in very rare circumstances, he might turn to the VE and say, if I find that this person, let's say, I would make it a ridiculous answer, is a quadriplegic. May I presume that there are no competitive jobs for a person who's a quadriplegic absent significant accommodations? Yes, and that hearing would then be over. But otherwise, the judge is going to listen, unless the judge is going to approve the case on the record early on. And sometimes, they'll ask 4 or 5 questions. I've had this happen recently. Ask just a couple of questions. They've looked at the medical, looked at my brief, and they'll ask, they'll ask these questions like, Mr. So-and-so, looking at the record, it looks like you've got 3 herniated discs. I'm assuming that you're in a significant amount of pain on a daily basis. Yes, Your Honor. And that pain is such that it interferes with focus and concentration, and that would leave you bedridden for at least 2 days of work per month. Yes, and I'm assuming further that the medications you take cause significant problems with focus and concentration and make you very, very drowsy. Yes. Say, counselor, I've looked at the record, and I believe that the record is supportive of a finding of disability. I don't have any more questions. And they may sometimes ask questions to the VE. They may not. But the VE is not going to testify independently unless the judge asks. So the hope here would be that the judge has reviewed the evidence and feels like it's so compelling that there doesn't really need to be much more done. And again, I've had a number of what I call 5-minute hearings. The case is really, really strong. I make a strong argument in my brief. The judge obviously buys it and goes with it. I had a couple with the same judge last week, already got a favorable decision on one of them. So, it'll happen sometimes, but, it just depends on the quality of the case. Stargirl. Good evening. I've noticed some doctors are adamant not supporting their patients' disability claim, SSDI claim, besides their personal beliefs. Is this due to some legal or professional consequence. I think it's going to depend on the doctor. I think some doctors don't want to get involved in disability evaluations. I think sometimes there could be some malpractice concerns. I've never asked a doctor about this, but I suspect that, if a doctor is going on record saying that a person is disabled for Social Security purposes, and that doctor has treated this person and maybe done a surgery or treated the person 5 or 6 years, could an argument be made that there was negligence in that doctor's treatment of that person? And so the insurance company may say, don't get involved in disability because it could put you in a situation where that could be used against you. That could be it. I think some doctors I know are concerned about getting subpoenaed and required to appear at a hearing. They don't know that the hearings are done by phone or video and they won't have to appear. And I think some doctors just feel like they're not equipped to make a vocational assessment, or they don't want to spend the time because time is money and they don't want to spend the time. But I do notice some doctors just won't do it. And I will tell you that, it used to be that was a much bigger problem than it is now. I win a lot of cases without a functional capacity evaluation. I've got medical, records. I've got objective tests, MRI, CT, things like that. My client's testimony. I think judges realize that some doctors just, they're really, really busy. They don't want to get involved in that. So I don't think it's as big of a deal if you've got a good, solid medical record going on in the background. But if you can get a doctor who will support you, that will be helpful. And sometimes, the doctor will say the record will talk about problems with activities of daily living, which you can use that. But I do notice that more doctors are less inclined. I chalk it up personally to they don't want to spend the time or they're concerned about potential liability, as opposed to they don't want to help you. They just don't feel like that's within their purview to do so. But I will say that. Yes, I've noticed that. Trish Wade, good evening. Hello, Trish. How are you doing? Elliot Franco says, good evening. How are you doing, Elliot? Precious says, hello. Hello, Precious. Rodney, one of my longtime viewers, former client of ours, says, hello. Good to see you. Sarah D. My attorney's office says hearings are being scheduled out a few months right now for them. They should be on July or August. So I've met with my attorney by now to go over how they plan on, I'm guessing, let's see, here we go, on helping me win my hearing. I haven't seen my attorney's too busy. Now, I think that, what's going on now, and let me give you some perspective on it. We have to provide Social Security with our availability. So I did my availability today, before May 1 for October hearings. So hearings are going to be scheduled for October in May and June. So my availability has already been set. Until the file is worked up, and what I mean by that is the hearing office has to take the raw file and they have to number the exhibits. And that is something done at the hearing office. And that's usually done 4 to 6 weeks before the hearing. Honestly, your attorney, until that's done, it's hard to know what's in the record. Now, you could look at the unworked up record, the non-worked up record, and see what's there, but you can't really write a brief on it because you can't reference a page number. In other words, when I'm writing a brief, the medical record is at section F, so there's other forms at section E. So let's say I'm referring to the medications list, that may exhibit 18E, or I'm referring to an MRI, maybe exhibit 27F, page 14. I'm going to need that so to really do my preparation, because if I don't have that, I'm looking at raw data and it's very hard to prepare because you can't refer back to anything. And, realize in this practice area, most attorneys who do this have a lot of cases. And so if I start working on a case and I have no exhibit number to really refer to, I'm going to have to duplicate work down the road. So I don't think it's that unusual for the attorney not to necessarily be in touch right now. Once the file is worked up, he or she should. Now, sometimes, I'll look at a file early on and I'll look at the raw data and I can kind of tell my client, here's my working theory. You're 57 years old. You've got back problems. I see this as a likely grid case, and I'll go over that with my client, or I'll make that argument to an adjudicator. But, I don't think that, it's too late until the file is worked up. Once it's worked up, then I think that's when your attorney needs to get busy. So that normally is going to be 4 to 6 weeks out. You're a little bit before then, so I wouldn't be too concerned about it. But I think, you can certainly ask your law firm, when they expect to be in touch, and what the time frame is. I mean, sometimes, records are coming in. I may not talk to somebody until a few days before the hearing. I may be emailing them ahead of time. And typically what I do is I'll send my brief, before I even talk to my client and say, here's the brief. Let's use this as discussion points. And then we'll kind of work on that. And then I'll adapt it or modify it after talking to the person. But that's kind of the way this practice goes, because, I mean, we're all, working on a lot of different files. And again, you've got to be able to refer to something specific so that you don't have to go back and reinvent the wheel. I mean, again, it's just, you want to make sure you're making the most out of every second here. Okay, Ronaldo. Productions. For medical reasons, diabetes since 2008, I need to stop working by the end of the year. I'll turn 62. Should I apply for retirement, at least for that, and disability right away when I can't work anymore? Well, if you're 62, when you apply for disability, you will have the option in the form to also apply for retirement. So I would say do them at the same time. That will get you money coming in right away. I will tell you that one of the issues with going for retirement, and I would definitely do that because you want to get the money coming in. I would find out what the difference in money is between the early retirement and what you might get on disability. So get your My Social Security statement. If that difference is $200 a month, $300 a month, you're going to have a hard time finding a lawyer for disability because the attorney only gets paid 25% of that difference because, you don't get paid on the retirement money. So if the difference between early retirement and disability / full retirement is $800-900 a month, and cases are taking 24 months, you could multiply $800 or $1,000, whatever, by 24 months. Okay, it's worth getting involved in it. But for $200 a month, times, $200 a month, let's say times 8, 12, or 18 months, it's not really worth it. So just be aware of that some attorneys won't touch it if the difference that you're fighting over is not, $500 or $600 a month. Not all. I'm just saying that is just a concern to put in the back of your mind. But obviously, it makes sense to get money coming in if you can. Obviously, you want to make sure you can eat for obvious reasons. So, okay. RD. Have I been before ALJ Clara Arnada? I have not. I'm not familiar with that judge. Let's see if we can give you a number as far as her approval rate. And again, I understand why people want to know that. Here we go here. It is, it can be a concern, but let's see here. But, you don't have any choice. Okay, let's see what we got here. Arenda, that would probably be. Okay, it says here, and there's a bunch of places, it shows 54%, which is above average. So that's good. The average nationally is about 49%, 48, 49%. So you have a judge there that's 54%. That is good. So you drew a good judge. So, I don't know the judge, anything about her, but, her approval rate percentage-wise is one that I would be happy with. Okay, Laura James. I've been waiting for 3 years. Turned 60 on the 14th of April. Just a good guess. Had both psychological and physical exam. It's too long. I mean, you're at the outer reaches of how long it should take. If I was in your shoes, I would contact my U.S. Senator and say, look, I applied 3 years ago. This is a terrible financial hardship. Why is it taking so long? And will you make an inquiry and find out? And that's what I would do. So I think that you're in the outer end of it. So yeah, it shouldn't take that long, but you're already taking way too long. All right, so Deb, who's in northern Iowa, says it's 70 degrees there, terrible allergy season with lots of storms. I was talking about the weather, but that 70 is very nice. never been to Iowa, but we're sort of getting past here in Atlanta the allergy season. It's still some, but we had it really bad about 3 or 4 weeks ago. And again, we're already in the 80s. So, okay, so RD has a hearing with Judge Aranda. Again, you're in pretty good shape, it looks like, with the percentage approval, at least. Much better than having a judge like I had with a hearing, 12%, who denied it. We're going to appeal it. How long does it take to get back pay? Generally speaking, after you're approved, you should see some money within 2 to 4 weeks. Sometimes it can be a week, but I would say within a month. Jen and the GLO Ginsburg law offices now they've got a name for themselves. The Glodden girls. One of the other staff members came up with this. Who's actually very young. She'd never heard of the Golden Girls, the TV show. Or she obviously she had, which I was surprised because she's in her 20s. But anyway, Jen is here. Jen, I thought was not going to be here, but she's going to be here at least for a little bit. Okay, George Graham. If a VA gets vet at $770 a month, can they get SSI? Well, the SSI amount in 2025, SSI in 2025 is $967. So if you're getting $770, at a minimum, they're going to reduce the SSI by the $770. So you might be looking at a couple $100, $190 at most. So it does not automatically disqualify you, but it's going to eat up a good chunk of the SSI. So you might be getting another 100, 150, 180 bucks, but it won't disqualify you automatically. My attorney never calls me either. And I understand people get really frustrated when they don't hear from the attorney. Here's the truth of it. There's nothing sometimes going on. I mean, you don't want to call somebody and say, well, nothing's happening. And Social Security doesn't do a very good job telling us what's going on. What I do when I'm working my case, I'm getting ready for a hearing. Now, what we do in our office is we have an email system, we have a text system where we're telling people kind of what's going on. We have it's called My Case, a portal where you can log in and see what's going on. But, this is just not something where you're going to just call somebody up in chat and say, well, I don't really know what's going on. I'm hoping it's going to be moving faster. It just doesn't, there's just not time to do that. So, don't be, in my opinion, and I am an attorney, obviously, don't blame your attorney for not calling you to tell you there's nothing happening. Now, again, what I do is in these text messages, I'll tell people, here's how you communicate with your senator. Here's a sample of what to say. So I'm guiding them, but some of that is, automated. Some of it is maybe live. So, again, time is money. I just got to tell you. And Social Security disability, they limit the fees, and you make the best of your time. So this is just not something where you have a 3-year time frame where nothing is happening for most of it, where you're just going to call somebody up and say, hey, just want to just chat and say hello. It just doesn't work that way. So I wish I could tell you differently, but that's just the way it is. So we try to balance keeping people updated and communicating with the realities of this practice area. RIP DT Tinea. Not sure what that means. I had back surgery a year after my date of less insured, but I had several consultations and opinions before they decided I needed surgery. The ALJ said none of my impairments warranted until after the DLI. Not true. Yeah, I think you make an argument there. I mean, again, this would be something where the evidence, as of the date last insured, needs to show you had a serious problem. Back problems don't just arise out of a vacuum. Now, a lot can happen in a year, but the question is there enough evidence going back to the date last insured to say that your condition was, close to a need of a surgery? Or maybe another way to ask it, was there something that happened after the date last insured until you had the surgery that changed things? Did you have a fall? Were you in a car accident? If there was nothing like that, especially if you have medical opinion evidence saying that your condition was, at a disabling level before, as of the date last insured, you got an argument. I think you're going to need medical opinion evidence from your doctor to do that. But yes, some judges, are not reasonable about that. But like I said, if you had a car accident, 6 months after your date last insured and things got worse, that's going to make it more of an uphill battle. Elliot says, would it be more beneficial for me to take a leave of absence for my job until after I get SSDI, or should I resign? I don't think it makes a whole lot of difference. I mean, again, if you're not working, you're not working. If you take a leave of absence, it's really kind of the same thing. And you're hedging your bets a little bit, I guess. You could certainly, make an argument to Social Security that you took a leave of absence, with the hope that you'd be able to come back. Now, look, a judge might look at it and say, well, you were hedging your bets so that you could go back if you got denied, which suggests that, you think you could work. Some judges might see it that way. Others might say, I appreciate the fact that you're, trying to keep your options open. If in a perfect world, I would probably rather have a resignation than a leave of absence. But, I understand why you would go the leave of absence route. That's just, it kind of is going to depend on the judge ultimately. I'm on SSDI, not SSI. If you want a lawsuit, I'm not sure about the reporting. It's not going to affect your benefits. I don't think you would, to my knowledge, I don't think you need to report it because it is not earnings. Now, Social Security will get a notice of it because the insurance company will send you a 1099, and they may ask you what that was. So it might be to your benefit to report it and say, this is a personal injury settlement or, whatever kind of settlement it is. And so that when you see a 1099, that is not from earnings or from work, because they're going to find out anyway. So, given that it's going to cause some questions, I would probably be proactive, let them know it will not affect your benefits at all. All right, so Rip is the person who had back surgery after the DLI. My knee surgeon said I was too young for surgery. It's documented. How can you just ignore that? Well, again, if it was ignored, I think that if the knee issue was something that is, even approaching surgical necessity, that would be what they call a severe impairment. And it's step 2 of the sequential evaluation process that has to be addressed. So if the judge did not include any reference to a knee problem in his hypothetical to the vocational witness, that would be reversible error at the appeals council. So again, if your knee issue is one that surgery would be appropriate for, that needs to be addressed in the unfavorable decision. If not, again, I think it's that would make it appealable. But again, if you're young, that's going to be another issue there. I mean, I've said this before, I think last week, and weeks before, if you're under 50, it's really an uphill battle because judges are just not approving as many cases for people under 50 unless you've got really overwhelming, really compelling medical evidence. All right. A la 2001, good evening. Afsana, how are you doing? I hope you are doing well. Precious, I have a hearing Tuesday. What's the best advice you can give me? I would tell you that you want to really focus on those medical issues that cause work limitations. That's number one. The main issue in a disability case is whether you have a medical condition that prevents you from working. And you want to be very, very specific. So you don't want to say, I can't sit very long, can't stand very long. 5 minutes, 10 minutes, 30 feet, whatever that may be. So you want to be very specific. You want to talk to your attorney about the questions you're going to get. You're going to be asked about your past work. You're going to be asked about, if it's physical, your capacity to sit, stand, walk, crouch, crawl, kneel, stoop, things like that, how much you can lift and carry, postural, twisting, turning, bending. Do you need help getting dressed? Do you need help bathing? Personal care, things like that. Just to be very specific, you want to paint a picture. I would tell you one thing. You want to paint a picture of a person who is applying for this disability because you have no choice. You don't want to be here. You'd much rather be working, but because of medical issues beyond your control, you simply cannot work. And that's why you're here. And you can be very specific about those things that you cannot do. So the more specific you can be, the better. I would also tell you not to ramble. The judge is going to be focused on your condition as of your onset date. I've had people at hearings sometimes talk about, well, I was in high school, I fell off a truck, or I fell off a horse or something. But if you work for 25 years after that, there may be some residual effect of falling off that horse, but that's probably not disabling on its own. If you have a condition for which you've received no treatment or minimal treatment, your family doctor is giving you, a mild antidepressant. That's probably not going to be something that a judge is going to find severe. So, I think that just, you want to talk to your attorney about those questions that your attorney knows is going to be asked, and you want to be very specific about all the questions that the attorney says this is what's coming, but don't not eliminate not very much, not very far, any length of time, things like that. Not too much, very very little. Not eliminate those from your vocabulary. That doesn't mean anything. That won't help the judge at all. You want to be very 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 specific, and when you do that, when you testify, that's really the main thing I think people get in trouble with. Why is SSI so hard to get? It's ridiculous. It seems like some joke. Okay, now again, Doug, are you talking about SS disability in general, or are you talking about SSI in particular? SSI is a program in the disability universe that is essentially for people who don't have any earnings record, or they don't have enough earnings recently. So it's a means tested program, meaning they look at your household income, they look at assets, and you can be disqualified unless you're basically dirt poor. So that's SSI. SSDI is the disability part where you've paid into the system. It's the same trust fund that deals with the retirement. So to answer your question specifically about SSI, the definition of disability is the same for SSDI and SSI. If you're asking why the income and resource limits are so low, they haven't been changed in years. It's just because Congress doesn't see the imperative to change them to make it easier for people to get on. It traps people in poverty because if you work at all, if you have any kind of assets, they disqualify you from SSI. So there's no incentive to try to better yourself when you have an SSI case. If you're talking about SSD in general, SSDI and SSI, it's because I think that in Congress there is no lobby for people applying for disability benefits. It's not like there's an organized group like the AARP that really is focused on disability. People in Congress, their focus is raising money and to satisfy powerful constituent groups. People pursuing disability are not that. And so there's no political, necessity for Congress to be focused on it. And they see it as a cost. And I think that given that this trust funds are going to run out of money in 10 years, they see disability as an easy target where they can, reduce people's access to it, make it harder to get, and reduce those, the trust fund outlays, and therefore, it's less, less money has to go out, and they don't have to deal with a very difficult conversation they're going to have to come up with at some point, and that would be raising taxes. Certainly, the current administration won't do it, and what's going to happen is if the trust fund's going to not run out of money, but they're going to have to start cutting benefits in 2035, let's just say, in, December of 2034, Congress will take up the issue. They're not going to look at it until they absolutely have to. And what they will do, it's going to depend on the makeup of Congress and the president at that point. And if I had to guess, they'll kick it down the road more. They'll allocate money from someplace else to Social Security to keep it afloat for another 5 years and let somebody else deal with it. Laura says, what if you refuse to get another CT scan because of the amount of radiation? That is a legitimate concern and you can refuse. Now, again, objective tests like CT scans and MRIs benefit your case, number one. So having a CT scan recent that shows a significant problem will benefit your claim. So that's a consideration. Secondly, the amount of radiation in a CT scan is not great. So it's not a huge amount. So even though I think it's reasonable to say I don't want any radiation at all, um, some judges might recognize that refusing a treatment is not something that can hold against you, but they might see refusing to undergo a CT because of radiation concerns, absent unusual health issues, is not the same as refusing surgery. So, I think the questions to ask here would be, will another CT scan benefit me in my case? Number two, have I talked to the doctor about the radiation issue? Am I uniquely fragile in that regard? And number three is, is there a concern here that a judge might in fact hold it against me because, that concern is not, again, the same level of having surgery. So I just think these are things to think about. I'm not telling you what to do or not to do. I'm just saying, I would say think about those factors and, don't spite your nose for the sake of your face, is the old expression. Not undergoing a CT, you can say, I told them they're not going to push me around, but then have a judge deny your case because the last objective test was 4 years ago when the CT would have shown something significant. It doesn't really benefit you. So I think I think you need to do your due diligence is what I'm getting at. Georgia rent assistance will never open an account if you have SSI benefits and never give you cash aid. Again, I don't deal a lot with SSI cases just because, unfortunately, a lot of times there are these offsets for, support and things like that. And honestly, the cases take the same amount of time, 2 to 3 years, same amount of work. I've got some SSI cases where, either there turns out there's an offset at some point and, there's no money paid, or the benefit, the attorney fee is $200 or $300. And so I've gone through 3 years and taken up my staff time and I'm losing money. So I'm just not as inclined to take SSI cases. So I don't really have much to comment about. I'll take some, but not a whole lot. But, I know that again, it's designed almost to trap you in poverty, which is another reason I don't really like them. I did my magic. Well, you know what? I appreciate that. The hard work is the client. I mean, I think that it's always good to get a favorable decision. I'd like to think I have some part of that, but the medical issue, the medical is really strong. Good testimony is really, really helpful. I appreciate your kind words, and again, I like to think I'm showing provide some value. But again, it's a team effort. It's not just me. It's Jen, it's Madeline, it's Kayana, it's Darlene, it's Paola. I mean, it's the whole crowd. Hoping to leave somebody out, Madeline, Darlene, Kayana. So it's the whole group, and everybody is working hard to Iris. Didn't forget Iris. It's everybody's working really hard to make these cases get these cases approved. So it's not just me, and of course my client has to listen to my advice as far as how to testify and cooperate with me. And that helps a lot too. So again, we're all kind of in this together. But yes, you got approved. How long does it take to get back? You should have it. Tell me, if you would comment your first name so I'll know who you are. I don't Miracle After Miracle, I don't, doesn't ring a bell. And let me look to see if I've gotten paid. If I've gotten paid, you should be getting paid. So that would be helpful to know. I got to change. I had a past one with regurgitation. Okay. Again, I will not comment on that. The objective evidence from subjective prob, it's all a bunch of nonsense. Plus, congratulations on the win. This is not a winning thing. Well, again, some subjective problems like a chronic pain condition, something like CRPS, which is a chronic pain condition that's not really subject to objective evidence as much. Fibromyalgia is one, idiopathic conditions. You may not have, an MRI or a CT, but if you have doctors who are treating you that say that, yes, this condition is legit, migraine headaches, we've tried a number of things. I'm convinced my client my patient is not drug seeking, that my patient is honest, and that these symptoms really do exist. That's the kind of evidence you've got to have. Again, as you sort of picked up on and you sense by your question, there are judges out there who seem to believe that unless there's an MRI of it, it does not exist. And that can be really, really frustrating. I told the story before, but I'll repeat it again. I had a fibro case in front of a judge here in the Atlanta area who's notorious with his very, very low approval rate, doesn't approve any cases where there's subjective evidence. Of course, he denied the case. We appealed it and went to federal court. And I worked with some federal court attorneys to work on the federal court work part of it, because that's sort of a different part of this practice. Anyway, we got a remand from the federal court where the court basically said in the instructions to the judge that you've got to consider subjective evidence, because the ruling on fibromyalgia is, the claimant's testimony is got to be given due consideration. And the judge read this. I don't think this is necessarily what the federal court meant, but the judge read it as meaning you've got to believe this person. So I'm not going to argue with him. I mean, I did happen to believe her. I think she was legit, as not every fibro case is, but this happened to be one. And so he approves the case. But what he did was he wrote a 2-page footnote in which he said, I disagree with the appeal with the district court. I think they're forcing me to do this. I don't believe this person. I don't think this case should be approved, but I'm doing it because they're forcing me to do it. And then, of course, he disapproved my fee agreement, which eventually I got paid through the district court. But that's a different story. But he approved. This is a low-paid judge. I think he's down below 20%. A low-paid judge approved this case based on subjective evidence. So it can happen. But I think that if you have a case based on subjective evidence, you need to have medical support from your doctors that say this is legit. You need to have an extensive treatment record showing you're undergoing all necessary treatment. You're doing everything you're being expected to do. Maybe you have a pain diary or a symptom diary where you can explain, what's going on, and you can track it. You're following treatment, whether it's medications or some other type of therapy, and nothing is getting better. I think you just have to, maybe you have a third-party statement from a former coworker, or maybe a third party that knows you that basically says you are truly suffering and they observe it. You can build a case based on subjective evidence. It's just harder. It's just harder than you hope, like heck, you get a reasonable judge. And as far as the winning, Doug, it is a winning thing. I mean, you got to win. Social Security, they take the position that the money in your account is their money, and you've got to convince them. You have, essentially until step 4 of the 5-step process, you have the burden of proof to prove that you are disabled. You've got to prove you're disabled. They have the burden at step 5 to show, after you prove you can't do past work, that there are other jobs, but that you could do. But at the end of the day, you have to prove that you meet their standard of disability, your definition of disability. So you've got to win. So it is about a winning thing. I got changed. 2 SSI benefits are mostly for one. Not sure. Bad luck with getting a bad judge. Yeah, and again, I don't mean to be negative about this, but yeah, you draw a bad judge, and this has been a complaint I've been voicing for 20 years, and the statistics about judge approvals are available, in multiple. Just type in approval rates disability judges, and you'll see. And you can look in any one hearing office. And again, before COVID, I was just local. And so it's just the Atlanta hearing office. Now I'm national because I can do it from phone or video. In Atlanta, downtown, there was a judge who paid 80% of cases. There was another judge who paid, just retired, thank goodness, 17%, 17%. You draw a judge 80%, you're going to win. You draw a judge 17%, you're going to lose. Complete lottery. No rhyme or reason to it. So you tell me why the same case gets approved with Judge A, gets denied with Judge B. That is a lottery. That is not fair. That is not justice. That is Social Security. It just is. I don't know what else to tell you. It just is. So it is really, really frustrating in that regard. But yeah, that's a lot of it. I breathe a sigh of relief, like somebody asked me about this judge. Um, you know, with a hearing coming up next week, 52%. Like you got a favorable in the lottery. That's a real important thing. I drew Judge 12%. In Charleston. If you're in Charleston, your attorney, you know what I'm talking about. I got unlucky with a case that should have been approved. We're going to try to get it approved on appeal, but just happens. RD. Okay, I'm 56, have chronic bladder and pelvic pain due to mesh erosion complications, surgeries. Can a psychiatrist, mental impairment questionnaire help my kid? Yes, I think that, depression would be a reasonable thing to expect given what you're going through, situational depression. That would, at a minimum, reduce most jobs from any sort of a job requiring focus and concentration, maybe down to a simple entry level job. You could possibly make a grid rule argument that because of the weakness in your bladder and pelvic region, you could not do even sedentary or light work. That you couldn't do medium work. You'd be limited to light work at best with no transferable skills. That would be a grid rule argument, or you could argue functional capacity that complications, i.e., pain. Maybe there's some reason you're missing work. Maybe frequent restroom use, painful restroom use. Likelihood of missing 2 or 3 days of work per month. Good case, it sounds like to me, because of all these issues. You're 56 with a documented problem that it's reasonable to expect would cause work limitations. You're not going to be able to focus and concentrate because of the pain, maybe the medication. So, yeah, I think that's a pretty good case. My medical, I think you're asking about, I'm not sure if you're asking about Medicaid, but I don't know here. Do all the ALJ have to consider the chronological evidence and how it links everything together? Most decisions do follow a chronology. I know when I do my briefs, I will try to go through a chronology. I think that generally speaking, I'm a big believer in telling a story, talking about, how you got from being productive and working to not working. So that's a narrative. And I think the chronology is part of that narrative. So I think most judges do want to get that story told. Realize as human beings, we are hardwired to look for stories and listen to stories. Cavemen tell stories, little children. I've got my granddaughter. She likes to hear a story. So I think if you can present your case as a story of how you got from here to there and how you're fighting, that goes a long way. So I think, most judges will look at the chronological evidence. In fact, when I do my pre-hearing analysis, I will do a chronological abstract of the record so I can see over time what is happening, not by body parts. So I won't look at just the back and then just the knee and just the shoulder. I'm putting it all together as time goes on. And you can sort of see over time a deterioration of somebody's overall health. And, at first it was the back, and while they're recovering from the back, they fell and hurt their knee. Now they got back and knee issues, and because of the knee issues, they had to hold off on surgery. Then there's a depression element that arises here, and that's causing additional problems. And you start to see the story unfold, and so that's why I'm a big believer in having that story unfold, whether it's in a pre-hearing brief or in testimony. So yes, tell your story. Jackie. Okay, so we just got our favorable decision. Sent a copy to Jackie and her husband because he wanted her 202.06. We realize, and if you look at the decision, he wanted her 202.06, but also functional capacity. Given his age, I think it's very unlikely there'll be a CDR. I would tell everybody, given the climate right now, never assume there will not be a CDR. I personally don't think in his case there will be, but you never want to assume that. And so continue going to the doctor, continue, keeping track of the medications. Again, I think very unlikely there'll be a CDR, but, you don't want to just, stop going to the doctor. It's important to go to the doctor to get better, continue to try to get better. So, assume the worst case and be ready for the best case. So if down the road, 3 years from now, they did a CDR, would he be able to say, I've legitimately tried to continue getting better? If he, and I'm not talking about him, let's just say a person who gets approved, they stop going to the doctor. Then there's a CDR 3 years later, and there's no medical evidence. There's nothing. The person's not going to the doctor for 3 years. What do you think a judge is going to say? Well, he won his case, therefore, and then he stopped going to the doctor. So, we can assume, Social Security assumes not going to the doctor is the same as not needing to go to the doctor. So, if you stop going to the doctor, that's sending a message to Social Security. So the answer is, I don't think there will be a need for a CDR, but assume there could be and be prepared for it. Yeah, people who need funds. Yeah, look, you say getting screwed. The system is not fair. No question about it. It is not designed to screw over an individual. People sometimes will say to me, they are trying to screw me over. No, it's not personal. It's just that Social Security is running out of money. The disability part of it is not, there's no lobby. So they see it as an easy way to reduce the outflow by tightening up on disability. There's also a false narrative in Congress that a high percentage of people pursuing disability are milking the system. And that's just what it is. So it's tough. I'm not sure what you're asking me. No hygiene item information where to get to over-the-counter items. I don't know what that means. Sorry. Okay. Goodbye. Okay. Applied on January 27th, says Chuck, and was approved on March 20th. Yeah, I think that we're seeing more and more cases where there are really significant problems getting approved, getting caught early. They want to do that. They want to catch them early. I got an email, for example, today from somebody who has stage 4 lung cancer and, a lot of problems. And so I wrote her back and I said, look, there are 3 compassionate allowance sections for lung cancer. She didn't say what type she had, small cell, large cell, or the third type. I said, but you meet a listing and you meet the compassionate allowance. You don't need a lawyer. Just in your application, reference the appropriate compassionate allowance, reference the listing, and say, this case should be processed for early approval. If you get turned down, let me know. But you're not going to get turned down. So they are looking to catch those early. And yeah, that's what should happen. That's what should happen if you're really, really serious, have a serious medical problem. But congratulations. Did I ever run into an irate judge? Irate meaning have I run into a judge who is just unreasonable and just completely outrageous? Not for a very, very long time. I've had judges who are clearly have a different vision in their mind of what it takes to be disabled and who can be rude to claimants. There's again a judge that I've been in front of many times who became, was very upset with my client because duplicate medical evidence had been submitted. And he felt like that was a waste of his and his staff's time. That's about as close as I can remember. I remember there was a judge. There's been a couple of judges I've been in front of who were just not very nice people. And they kind of made it very clear that they didn't believe what my client was saying. My feeling is that, and again, there's always exceptions to all this, but most people, I'd say the vast majority of people who apply for disability legitimately have an argument that they are disabled. They've tried to work, they can't work. Whether the evidence supports them or not, I don't know. But I think most people who try do believe that they have a legitimate concern, a legitimate case. And I think that judges need to treat everybody with that respect. Okay, you may not accept their argument. You may think the medical is not strong, but at least respect the fact that they are, making a good faith attempt to meet a very difficult system. That they stopped working. There had to be a reason for that. That they are, legitimately have a problem that would make them make a difficult decision to stop working. And for a judge to sort of dismiss somebody and to just not give them the time of day, I think is inappropriate. Some judges will do that. They just, that's just where they are. They're just not nice people. But most judges, I think, even if they're not going to approve the case, will show a little bit of respect. So irate is probably not the word I would use. I've had unreasonable, I've had disrespectful, I've had, just judges who are just off the wall, but not somebody that I've come across who's just like angry at the world. That's just in my experience. Okay. I'm one of your clients. I'm waiting for a decision on recon over a year. Sent a request. My senator still waiting for an answer. It is more and more common. I mean, there's a real problem in Social Security that, when Doge first came around, they sent out these letters to Social Security employees offering them a buyout to leave. They just sent out another one. And if you look at, there's a lawyer in North Carolina named Charles Hall. He's got a blog, and he posts about this. And Charles is very opinionated, very anti-Trump. I will tell you that. He's very cynical about the whole process. But he gets a lot of former and current adjudicators commenting on his blog. And the consistent theme I'm seeing is this is a mess right now. There's not enough people and not enough trained people. There's been a lot of turnover, and things are falling apart. They're this close to just completely collapsing. Is that hyperbole? I don't know. I'm just telling you what I'm seeing on this blog. And I think that in some places, the system is a real mess. Commissioner O'Malley, the former commissioner, who's very outspoken about this, and some, in the NOSCR community think he's maybe a little bit off the where maybe he's taking this a little too far. He's like warning of imminent collapse. The whole thing is just going to completely implode in the next 30 days. But he's been saying that for, several months. I don't know what to tell you. I just think that you've done what we need to do, and that is to enlist the aid of a representative, elected representative, and we will see what happens. But the system is in bad shape. They don't have enough people. They don't have enough, trained people, and it's going to be an ongoing problem. I don't know what else to tell you. Okay, Doug. Okay, again, this is one the irate judge. I've run into a few that I consider to be out of line, but it's pretty rare. Most of them are even the ones that are not high pays are at least reasonable, pleasant people, or at least businesslike. I'll take businesslike or pleasant, and it's rare that I find a judge who's not those things. Now, again, I submit pre-hearing briefs in almost all my cases. I know what I'm talking about. I got a little bit of gray hair. Many of them have heard about me. They've heard me just because I do a lot of teaching, CLEs, or my blog, or my podcast, or this, or whatever, live stream. So I don't get judges, and you can usually tell because I'm answering the questions, the preliminary questions, pretty succinctly. And this is not just me, but attorneys who've done this for a while, it's pretty obvious. I know when I first started, there was a judge who later on actually became pretty nice, pretty reasonable. But he was one of these type A people that like to be a bit of a bully. And I was kind of new at this. And, he was just trying to put me in my place. and I didn't know enough to really fight back. This is, again, 35 years ago. And as I got more comfortable with the practice area and I started pushing back a little bit, he backed off. And later on, we became actually pretty friendly. But yeah, there's some people that just like to show their power and power hungry. And sometimes you get judges who will do that, especially to newer attorneys. Fortunately, I've not had that happen very much. If a judge starts that, I'll push right back right away. Again, I've got to be an advocate for my client, and if the judge is being ridiculous, then I'm going to call him or her out on it. It doesn't happen very often, at least to me. Let's see here. Okay, so let's skip some of those. Okay, so where's the turnaround? St. Louis Grand says for a decision for vets rated 100% P&T post-hearing. I don't think there's anything faster about that. I think that the speed, the moving to the front of the line is more applicable when it comes to getting a hearing scheduled. I think once the hearing is done, I don't think that being 100% VA, rated vet is going to get you a decision faster. I could be wrong, but I don't think that's going to help you. Vince, one of my clients. Hello, Vince. How are you doing? Okay. All right. So Doug, having some side conversations there. Okay. Elliot had a psychological CE last week. Yesterday, received form 3368. Seems to ask the same questions over and over. Yeah, this is going to happen because they and the 3368 is what a function test, I think. They're going to keep asking you the same thing. It's not unusual to fill out that form 3 or 4 times. My personal thought is that it's a form of busy work, that they keep asking you to fill it out. You're going to think that they're doing something when in fact it's just sitting there. There's no reason to fill that form out 3 and 4 times, but they will ask you to do so. Again, I think it's busy work. And that you picked up on that. I think you're exactly right. This is just, they can't get these things out fast enough, so they just keep asking to fill out forms. All right, so we're saying hello, Chuck, and hello, Laura. How are you all doing? Doug is saying hello. Kevin Johnson, I need surgery. You're 59 years old, still in recon, applied 23, still waiting. I slowed down to a crawl or snail mode. Yes. Yep. So, 59 is a good age for this. It gives you a lot of advantages, either the grid rules or just the fact you're over 55. So if you've got something significant, you got a good argument there, I think. All right, Doug is on advice on, I guess, SSI. And let me just, I'll tell you, again, as I've sort of said it all along, Social Security disability defines disability in terms of how your medical issues prevent you from being a reliable employee. So the evidence needs to address your vocational capacity. There needs to be some form of a diagnosis. It needs to be medically determinable condition. And it's got to be something significant that gives rise to functional limitations that prevent you from working. And the more specific you can be, the better. That's how you win. You've got to have something significant. It's got to be vocationally significant, medically, vocationally relevant, and it's got to impact your vocational capacity. It really helps to have a compelling medical record or opinion support from a doctor, and that's what Social Security is looking for. Okay, Dolly Parham. How long does it take a decision after seeing the Social Security doctor? It just kind of depends. Normally the adjudicator is going to send you out for a consultative evaluation fairly early on in their process. And so if it's taking 8 or 9 months to get a decision in recon, I would say, that their medical opinion is going to be kind of the tail end of that. So normally it's going to be 2-3 months after the consultative, but there's no set time. No set time. TC Bird. Hello. Hello, TC. Hello, Bird. Okay. So Doug has got a room full of objective evidence. Well, then that will make your case that much stronger. Objective evidence is the currency that Social Security trades in. Okay. Okay. All right. Yes, I agree. It can be there. Duplicate paperwork can make things crazy. Yep, I agree. Great show. Thank you, T Cash. Started interesting as possible go on SS retirement. 62, let's go back to work. Realize it's 62 if you, and I'm not a retirement guy, but if you work there, they limit what you can, how much you can earn, and they start reducing your retirement. So you want to make sure you research that. Once you hit full retirement, then you can work and it does not reduce your retirement benefits. So do your due diligence about how much you can work. Denise says, I'm 59, have cervical myelopathy, have had 3 cervical surgeries. These are neck surgeries. My attorney does not want to meet 15 minutes before your hearing. That would concern me as well. I think that you need more than 15 minutes before the hearing. It needs to be a week, 3, 4, 5 days. Look, I spend probably an hour and a half to 2 hours on my pre-hearing calls. We go over everything, longer than the hearing, almost always. And again, that's after they've reviewed my brief. So I think that's a little stingy, in my opinion. 15 minutes before hearing. Dimple Bellamy, hello from Ohio. Thank you, Dimple. I appreciate that. Essay. For the medication intake form, do the failed medication trials need to be listed? Only the current medications. That is a great question. That is a really intelligent question, and I really didn't think about it that way. What they want on the medication form they send you is just the current medications. But what I would do, if you have an attorney, your attorney can help you with this. I would put together a form or a statement or something that discusses failed medication trials, and maybe it goes over the history of those failed medication trials. That would be compelling evidence. Maybe just an analysis of failed medication trials, and you could just make a chart, or you could just do it in a narrative form. That would be very, very compelling evidence, because failed medication trials are good evidence to show that your condition is one that is not treatable. It's medication resistant. So I wouldn't put it on the intake format. I would put it on some sort of another document, and again, an analysis type of document that your attorney can help you with. But that is just a great question, and that's actually something that I'm going to actually make note of this right now, because that's a really good thing to suggest, which I'll make a video about that, but it's a thing to suggest, to my clients, and maybe to, just as part of the overall video series there. Can someone in Nevada give an attorney from? Absolutely, because the hearings are done by phone or video. It doesn't matter where you live. I do hearings all over the country. I've got hearings in Texas, and in Maine, and California, Illinois. I have, like I said, I just put my availability in for October, and I've got, I think, what I do is I make a list of cases where I've requested a hearing. I have in the Ninth Circuit, which is California and out west, I've got like 8 or 9 that are scheduled for hearing. That's probably more than I have in the Atlanta area. So it really doesn't matter where you live. Okay, after winning, do you receive back pay? The monthly payments were in the process. Normally, the back pay comes before the monthly payments. So usually you get your lump sum at the same time the attorney would give his. Okay. Sharon says, right, Sharon, we know the congressional inquiry did work, and we won, which is very good. Good to see you, Sharon. I hadn't been here for a while. Good to see you again. KU Thunder. My pleasure. My pleasure. Jim says, hello, John and friends. Can I report injuries that exacerbate my condition? Let's document. Love your channel. Thank you for your work. You're welcome. Again, reporting an injury is less of, I think documentation is really the key. You could report it, and where that would come into play would be if, let's say that you had an injury, you're in the middle of your case, and then you have a serious car accident or something like that. That might trigger Social Security to send you out for a consultative evaluation. So I would let them know if there's something new, but I would also, get the medical evidence too. Um, if it's something serious, they have an obligation to develop the record. Obviously, you don't want to rely on them doing it with consultatives, but I think I would definitely let them know. You, Harold. Okay, thank you. Approved. Well, great. Thank you very much. I am very grateful for your kind words, and this is a good time now to put in my plug for, you know, testimonials. If you find this helpful, if my videos or my live streams have been helpful to you, please leave me a nice review. I've gotten some nice ones the last few days. What I do, I'll tell you, is after I win a favorable decision, I usually ask my clients at that point to write a review. It makes a big difference in terms of my visibility online. So if you are so inclined and you find this useful, please do it. Stephen Edwards, I'm a 45-year-old C3 quadriplegic, lives in a SNF. I'm not sure what that means. I just resumed work. State Medicare was removed from long-term Medicaid, retain my income at $70 a month. Any ideas? Honestly, that is beyond what I'm trying to get people on disability. This is really more of a Medicaid eligibility problem. And this might be a situation where you reach out to Greg. Why have such a block on his last name? I don't know. Greg Brinkley. Greg, if you're watching, I apologize. I just kept a block on your last name. But Greg at Greg Brinkley, GregBrinkley, Greg at gregbrinkley.org. I would reach out to Greg. This is something that he might be able to help you with. I just don't know. I don't like to guess, so I don't know. State to state differences. Yes, you're right. It's not state to state. It's judge to judge. Judge to judge. Just turned 59, pushing to work another 6 months to be able to draw off my 401k. Not sure if that's, I will tell you, having trouble with off-task time at acceptable levels. I will tell you, I'm not a big fan of going after your 401k early because, and even if you could avoid the tax penalty, that money is going to be needed down the road. But if you have to, obviously. I'm just not a big fan of it. So if you've got to work another 6 months, and obviously the disability process takes a long time, but you're 59, if you've got a significant medical issue and you're off task and you're being written up, that's evidence, by the way, that you could use. And of course the medical evidence, but so the answer is, I don't think that if everything else be equal, I would not be a big fan of going after your 401k, but if you have no choice, you have no choice. Look, you got to survive, you got to eat. So, that's something that you got to do. Teresa Dominguez. I had my hearing last Thursday. I was lost. ALJ didn't ask questions, left up the rep. What's your option with quick edit of Florida? That's who I have. I don't ever like to talk about other representatives or entities. I know Quick Aid's a non-attorney rep firm. I don't speak ill of anybody because I don't want them speaking ill of me, and I don't know. I never really observed them in action. I think that as a rep, let me just say this: you have to assume that the judge may say, "Present your case." I have at every hearing, I have a page where I have a list of the questions I need to cover, so that if the judge says it to me, I just go down my list, and if the judge asks questions, I check off the questions that have already been asked. That's basic hearing preparation. You should never be surprised by a judge who says, counselor or a rep, present your case. So, I don't know what your rep said or did in that situation, but it should not have been a surprise. Yeah, I think you want to, it's always wise to write down your questions. Absolutely. All right, Michelle wants to know, how long did it take for Harold to get approved? Denise Manson, I'm 59 with 3 surgeries. What are my options? Okay, I lose my hearing. You can go to the appeals council. Hopefully you won't lose it. And again, I think you can go on my YouTube channel. There's a lot of videos about hearing prep. Educate yourself. I mean, look online. There's a lot of other people out there. Michael Leiner has some. I think Walter Knott has some. There's a lot of videos about hearing preparation. Do your due diligence. Even if your attorney's only going to talk to you 15 minutes ahead of time, doesn't mean that's all you have to listen to. So educate yourself. If you should lose, the next step would be to go to the appeals council. And again, what I do is I work with a couple of different federal district court attorneys. I've had Adriana De La Torre was on here. She's one of them. There's a couple other people I work with. I'll have one of them look over the unfavorable decision. Are there grounds for appeal? If so, then they may give me some copy points. I'll write the brief, get it filed for the appeals council. If we lose there, they take over and go to the district court. Still no fee unless you win, but that's what you would do. The appeals council is the next step within 60 days of the denial. I don't have a direct complaint with my rep. I didn't like this contract reps to appear by phone that were going to call me the day before. I didn't prep you. Again, I'll leave that. I will tell you, I have done some, I don't really do it anymore because I'm pretty busy, but over the years, I did some contract work for a couple of non-attorney rep firms. And some of them did a pretty darn good job preparing the case. Now, what I would do is I would contact the claimant early, a couple of weeks out. As soon as I got the assignment, what they would do is they would send me a file with a bunch of medical evidence in it, and it would send me the contact information. I would immediately send the claimant, hey, this is Jonathan Ginsburg. I'm working with, an advocator group, or what are they called now? They're called something else now. Brown and Brown Servicing or something now. That's what they're called. I've been, retained by them. I don't work with them anymore. They're nice people. They did a good job. And so I'll be contacting you in the next week or so to go over your case. And there's been a couple other people, that I've done some work with, Brian Terrian before. But I personally feel like, okay, and I would do the same prep I would do for anybody, if it was my own case or their case. You don't know what you're going to get when they get a contract lawyer. There are contract lawyers who probably don't do a very good job. I don't know. But, I would not be thrilled about getting a contract lawyer that talks to you the day before you're here. I'll just leave it at that. And that may just be, you got one that was really busy. I don't know. 3 salient points in our waiver for overpayment for a very seasonal temporary job 18 years ago. So this is going back 18 years. One is there a statute of limitations issue? I don't know. As far as salient points, I mean, obviously not understanding the earnings limits. Honestly, if you look at the form to ask for a waiver, one of the reasons that people say is that I can't afford to pay it back. You could bankrupt on it, but I think that you could also argue that 18 years ago is so long. I don't have those records anymore. I can't. That it's patently unfair to ask me to produce records or to confirm what was going on 18 years ago in terms of what was in my brain or the work I was doing. And, I don't recall that I worked over the limit or where, so I think those would be some things I'd look at. But it's pretty unusual they're coming after you for something that happened 18 years ago, but I guess good. Okay, I think the things you're talking about are, um, are perfectly legitimate, and I think that you could try those and more. Absolutely. Yeah, I think. What do I think? Yeah, I mean, I think any argument you can make at the end of the day that somebody's got to make a decision that your actions were not unreasonable. But 18 years is a long time to expect, um, somebody to remember. How bad are the scams? Well, Social Security seems to think they're pretty bad because they've changed a lot of the stuff you have to go in person. I think one scam that was going on was people calling up and changing the bank account or where the money was going. That was a scam. I think that, people calling up and saying we're Social Security, we need to verify something, confirm your Social Security number. People give their Social Security number, date of birth, they could use that. So I think that you have to assume, I would be reluctant to talk on the phone. If somebody calls you from Social Security on the phone, they should have that information. They should not be asking you your date of birth or your Social Security number. They should have it. So I think you need to be very suspicious. Every day there's scams going on. You get these texts, ridiculous texts now. You probably have heard of the one where, you didn't pay a toll and click this link. That's a scam. The one where there's just all kind of different scams. One where your nephew, you need you to contact them about they're stuck in a prison in Mexico or something like that. Ridiculous things like that. Now there's one that's going on now and I've gotten a bunch of these. Somebody will say, "Hey, how are you doing?" Or did you have a nice dinner last night? From an unknown number. It's very conversational. And, the inclination is to, I'm doing okay. How are you doing? And it's from somebody trying to scam you. And they're going to try to, ask you a bunch of questions and try to gain your confidence. That's what I call them con men, and try to, get you to send them money. Just stuff like that. I've had, these texts, let's go out for a drink, stuff like that. They're trying to, what do they call it? Catfish you, get you talking to somebody that you think is a woman or a man and things like that. It's just, you got to be so cynical these days. If I get a text from an unknown number, delete. It just can't, you got to be suspicious. South Dakota. You had a question about your attorney retiring and not telling me to just maybe more. I'm getting my full stack size back because I was okay. Good for you. You did right. Good for you. Yes, I think you had a attorney retired and somehow didn't tell you, and he got paid, didn't do anything, and got your money back. Okay. If I forgot to provide on my intake form, absolutely, just email us, text us, whatever. We can add that. That form is fluid form because there's always going to be updates and changes. In fact, every email you get from us is going to have a link to a form where you can update medical providers. So not a problem at all. Lose the first hearing with attorney fee in the second hearing, you get 100%. Not necessarily. Well, first of all, if you lose your first hearing, you got to appeal it. So who's going to do the appeal? That's the first thing. And if it gets remanded back, unless the attorney withdraws and waives fees, the attorney will get paid. So, if you're asking me how do you, not pay an attorney for the work he or she has done, you come to the wrong place. This is not what this live stream is about. I work really hard for the fees I generate for myself and my firm. And, I've had a few people that do that. I had one joker who I got his case already and he terminated me right before the hearing. And then, I've not gotten paid on it because the judge won't address my fee petition. People do that. They're just dishonest. So, I got another case where I spent a ton of time on, and the guy had submitted his own 1696. They wouldn't approve my fee agreement. He won't pay me now. So you get people like that. They're just, jokers. They do it, but most people are reasonable, but some are just not. And what are you going to do? Okay, SNF is skilled nursing facility. Um, okay, so Deb knows more about this than me. Dee Dee Partlow, good evening. Been a long time. Yes, it has been a while. I've been doing well. I'm living the dream. Not sure whose dream, but I'm living the dream. Got approved in September. Took me 8 months, but I can probably breathe. Absolutely, absolutely. I think 8 months is pretty good. Pretty good. Um, let's see. Just want to say how it's definitely a battle. I'm usually 90% right, but this 1% never get because some things just not as the attorney may see them. Rose-colored glasses. Okay, you know what? You are proven correct. Well, he is improving. Thank you very much. If you don't know, my father-in-law, who's in his 80s, fell a couple of weeks ago and had a bit of a rough time of it. Anybody who's elderly who falls, it's not a good thing. Fortunately, nothing was broken, but it was pretty swollen. And, it takes a lot out of you when you're older. And, he's getting physical therapy, going to the doctor, definitely doing better now. But it was it put a lot of burden on all of us because we had to be, dealing with everything from running to get groceries to pharmacy to doctor's appointments. But he's doing better, and hopefully, in fact, normally we have every week we have the whole family comes over for dinner. My kids and my granddaughter, my father-in-law. So he missed a couple of weeks, so he was there last week, and he was at my house yesterday, and so he's definitely doing better. Thank you very much for asking. Sharon. In fact, Sharon and we talked about this a little bit. Sharon's one of my former clients, or my clients, I guess. And we talked about she had done something very interesting. She had written down the questions. I think we come up with identify the questions. She put them on like index cards, and then we went through them, and had kind of answers written out. You could do it on an index card because that way, if the judge asks a question, you could just have it right in front of you, just go right to it. Um, you know, you could do it on a piece of paper, but yeah, I think that you want to go through those questions. And actually, what I do is I'll go to my client. Okay, let's talk about your sitting, standing, and walking. So, how long can you, if you had to stand in line for the Department of Motor Vehicles, how long could you do that? Okay, just standing without support. And they'll say 30 minutes. That's 30 minutes. That you could stand for a half an hour without moving. Well, really, maybe probably 15 minutes. A lot of people overestimate their capacity. So get them to understand this is what you can really do. Maybe they could 30 minutes, but usually it's less than they think. I'll say, well, how much can you lift? Oh, about 15 pounds. Okay, 15 pounds. And realize that a gallon of milk is 8 pounds. You could lift 2 gallons of milk, 15 times a day. Well, not really. Well, so maybe maybe your frequent lifting capacity is 5 pounds, it's 8 pounds, and frequently and occasionally is 15 pounds. People sometimes just need to be, it needs to be brought to something like a gallon of milk where you can identify with it, and just get all that stuff in your head or in writing ahead of you. So if I ask you, the judge, how much can you lift? I can probably do about 5 pounds on a pretty frequently basis. Maybe I could do 15 pounds once or twice a day. Perfect. How long can you walk? About 15 or 20 minutes, and I got to stop and rest and sit down. How much can how long can you sit in an office type of chair? About 15 or 20 minutes, and I got to stand up and walk around for 5 or 7 minutes to loosen up. How often do you lie down during the day? I take a nap for 15 to 20 minutes to get the pressure off of my recliner 3 times a day. Or after taking medications, I'm really drowsy, so I lay in my recliner for 30 to 45 minutes, and then about an hour later, I'm better. That's this level of specificity you've got to have. And so, what Sharon's saying is, practice those questions with me if I'm your attorney or your attorney so that you have answers. You don't want to think about these things for the first time at your hearing. So if, how much can you lift? Well, I haven't really thought about that. I don't know, maybe 20, 30 pounds. Well, that may be completely unrealistic, but you hadn't thought about it because no one's ever given you, a gallon of milk's 8 pounds, or 10-pound bag of potatoes is a lot more than you a lot heavier, a lot more difficult than you might think. So those are just things you got to think about ahead of time. That's the point here. That's the point here. Um, if spinal issues are affecting an organ, it can be, I hate to say it just depends on how severe it is. How severe is it? I don't know. I mean, if it's affecting an organ, what organ? Is it your liver, your kidney? I think you need to give me more information. Okay, we're talking about the nursing setting here. Okay. So Harold took several years. The attorneys you had were not okay. Um, Unfortunately, several years is the more common thing. Dakota Grove, my pleasure. I'm glad you tuned in. Thank you very much for tuning in. Okay. I've left the crawl here in the review. I forgot about that there. Let's go ahead and do the case of crawl here. Okay. Doug, you're welcome, Doug. Thank you for tuning in. L. Brown, concentration is an important question. They want to see if you spend time on social media. So beware. Yeah, that's a very good point, L. I think that, I've not had judges ask people about Facebook and Instagram, but, I tell put it on private. It's really nobody's business, what you're doing, because maybe you have a kid who's on there. Who knows? But they'll ask you, are you on your computer? Do you do Facebook? I've had judges ask that before. And again, this is the questions you practice. I maybe get on the laptop, and I just kind of, surf the internet for maybe 15, 20 minutes, but then my vision gets blurry. I'm uncomfortable. I got to put the computer up. So I may be on a total of 45 minutes a day in 15-minute increments. You can just explain it that way. But yeah, if you're on a computer for 4 or 5 hours straight, on Facebook and Instagram and all that stuff, yeah, that starts to look like you could possibly do some work. Okay, answer the questions you maybe wandered off. And I will tell you that this is something, in fact, I've got a video, one of my more highly viewed videos, my YouTube channel, is why I'll be rude to you at your disability hearing. That's what the video is called. And that is because people do sometimes wander off. They will start trying to give a long history about things that are really not relevant. I mean, the judge is focused on your onset date forward. Anything that happened 15 or 20 years ago isn't all that relevant. Or, the story, people start talking about, the problem they're having with their kids, and their kids don't listen to them. And, it's not relevant. They want to talk about your medical issues and how they impact your functioning. So a good attorney can stop somebody from kind of rambling. And if they start rambling, I'll interrupt them and say, okay, let me get back to the main issue here. Let's talk about, and the judge will sometimes do it too, but I'll just say, okay, we're talking about your lifting capacity. We don't need to, we'll get into the hospitalization and the problems you had with the staff nurse later. But let's talk about your lifting capacity, because people will sometimes do it. They're nervous. It's on their mind and they want to talk about it. But we got 45 minutes. We got to hone in on what's important. Okay. That's exactly right. What I'm telling you, that I am telling you what I know. Okay. Okay. I'm 56, statutory blind and for SSDI. I would apply for DAC benefits. Disabled adult child. DAC only paid for 5 months. Not sure why it only paid for 5 months. SSDI would be higher. Should I apply for DAC? It's the same standard of disability, although DAC you have to prove you became disabled, I think, before your 22nd birthday, if I'm not mistaken. You're 56 now. So can you really prove you became disabled 40-something years ago? That's a tough sell. That's a tough sell. I think that's really probably not going to happen. So I think I would probably pursue the disability. Guitar Gardens, is a disability hearing mandatory? All cases are for a judge or proof of circumstances disabled. Push it through. They don't put. I mean, you don't have to go. I mean, there are some cases get approved at initial, some at recon, some will be approved by the judge on the record. I had a case a few weeks ago where I got a call the day before the hearing from the judge's office saying the judge has reviewed your brief, reviewed the medical record, and is willing to approve it. No need for the hearing. Okay, we don't have to go to a hearing. But I would say, don't assume that's going to happen. Don't assume it's going to happen. Assume that you may have to go in front of the judge. it's not that bad. I mean, 45 minutes, you'll be prepared if you have a good attorney. And most judges, I would say most judges are either polite or businesslike. Very few are not. And, it's just not that painful of a process. The big problem is just drawing a bad or low paid judge or an unreasonable judge. Okay. The question may have to explain. Let's stop for a minute. Okay, so Teresa's saying that her rep didn't really prepare her properly, and that's going to happen. And that's like I said, I've got a lot of prep videos on the YouTube channel. There are other people who've got them. Do your own. If your attorney's not going to do it, which they should, and even if they do, look at other resources out there. I mean, this is your case, and yeah, you hope you have a good attorney who can prepare you, but maybe another perspective, another voice, another voice will resonate with you better than what your attorney will say. Some attorneys don't communicate well as far as what they're trying to tell you. And again, it's taken me a while to get to the point where I have a kind of a presentation, if you will. And I always tell my clients, we want to present a narrative. We want to present a story. And let's here's how we go through that story. And here are the questions. So we're going to talk about the medical issues. We're going to talk about the questions you're going to be asked. But it's taken a while to get to that point where I can do that. Got my first SSI check in Amazing back pay. It should be coming anytime soon. It should not be much longer. I mean, if you've already gotten your first payment, your lump sum should be coming next 2-3 weeks, I'm thinking. And I think Elle's right. You apply like the person who said they got approved in 3 or 4 months. You meet the listing, you meet a grid rule. You could get, and they are looking to approve some of these cases faster. Okay. Loki says, my CE came back with no difficulty walking, standing, sitting, pushing, pulling. 59, which suggests this disaster report. Regular orthopedics want to get involved. Okay. I think, first of all, how long did the doctor spend with you in that exam? You could certainly argue that the doctor only spent 10 or 15 minutes. These conclusions are bogus. That's one thing. I think second thing is, what does the medical record talk about? Is that consistent with that, with these lack of limitations? Third thing would be, if this doctor does a lot of this, your attorney might be in possession of, of other reports from the same doctor that basically say the same thing. I've done that a couple of times where I'll get a report from a doctor who does these consultatives. That's all they do. One time I had 5 reports from the same doctor. They said the exact same thing. I redacted the names. I submitted them along with a letter to the judge saying, this doctor is using the same report. This should be given no weight at all. And the judge agreed, gave it no weight. So I think I would rely more on the underlying medical evidence. You could go for a functional capacity evaluation with a physical therapy practice. That would be objective evidence, could really help you. You could find a doctor, maybe your attorney knows one, who will do an exam of your own consultative evaluation. Again, extra cost item, but that's something you could look at. That's how I just would probably argue that, the doctor spent 10 or 15 minutes with me, didn't really, do anything to be able to make these decisions, didn't have MRI evidence in front of him, and just argued that this should be given little to no weight. The judge could decide to give it weight. But again, if you had a functional capacity evaluation, that would be probably more specific to the issue. If you had your own doctor review you, that would at least provide conflicting medical evidence that a judge would have to consider. The underlying medical evidence from your doctor would have to be, even the doctor won't fill out a form, would be something that could be helpful. There's just any number of ways to attack it. But, it can be discouraging. I've taken now to asking my clients how long they spent in the exam. And if it's 5 minutes or 10 minutes, I think we could have an argument that shouldn't be giving any weight. Okay. Yes, I know. I've sent a, just crazy week, and I've got the sitting right here. Call of Senna didn't do it, so I apologize to you, and I will make sure it happens tomorrow. Okay, Dee Dee, congratulations. Yes, that is good. Otis Amos, in the hospital now. Another bowel blockage from Crohn's disease. Got disability going now. My first denial, been in hospital 3 times. What are your chances? I think pretty good. I mean, you're being hospitalized for Crohn's complications. I think that's pretty significant. And I have very good luck with Crohn's cases because most judges realize that very hard to win, very hard to work when you're in the hospital or you're having to use the bathroom excessive amount of times. Special insured status include SSI link. I'm not familiar with special insured status as before age 31. I'm not familiar with that. You want to email me? I just use the case evaluation form. I'll take a look at that, but I'm not familiar with that particular program. Is the SSDI fund at risk of running out of money? Yeah, it's absolutely a risk. I mean, there's a trustees report every year, and it kind of goes back and forth. But last I read, it was something in 2030 something, 33, 34, 35, that it could run out of money. Now, again, Congress has the option of funding it with some other source. They could raise taxes. They'll deal with it somehow. It's not going to run it. We're not going to see a benefit cut, I promise you. No politician's going to let that happen. But what the solution is, I don't know. But yeah, it's a problem. Chat GBT can help you frame your response to the judge and take transcribed notes from these sessions better than your preparation. If you know how to prompt it. I've been testing some AI solutions. Chat GPT is not what I'm looking at because I don't think the information there is private. And I'm not going to put my client's information on something that's not private. Again, you can do what you want, anybody out there, but there are other ones out there that are more private. Again, you can ask it questions. I have framed questions to AI engines for various things. I'll tell you one of the things I use it for is coming with ideas for videos, and it can be really helpful. There's some really neat stuff that it comes up with. When it comes to case preparation, I have not found that it's giving me everything. It tends to leave stuff out. There's a recency bias. You got to be just really careful. So it can be a tool. It is not quite there yet, but it is a tool. But yeah, you can certainly put in notes and it will summarize them for you. It can do some really amazing things. But, would I trust it completely? No. In fact, there was actually a very, very interesting story that came out just the other day. You probably have all heard of the My Pillow guy, Mike Lindell, big Trump supporter. And I don't know what he did, but he got himself in some trouble for something. I don't remember what it was, but it was litigation. And his attorney submitted a brief that was created by an AI engine. And the brief used citations. In the law, you typically cite a prior case, let's say something in the Federal Reporter or whatever the precedent is. There was a contracts case and there's a line of cases in the federal, the Fourth Circuit, and you cite these cases. And in law school, you learn how to do this. And so maybe 211 F second 833, Fourth Circuit 1993. Something will be a site. Well, the AI engine made up a bunch of sites. They just made them up. They're bogus, and it was just kind of placeholders. Well, the attorney didn't do his homework or her homework and submitted this brief, and the judge started checking these sites like these cases don't exist. This is BS. And so those attorneys are going to have some real things to answer for. They're going to be some, they could get disbarred over that. It's pretty significant. So I would just say if you're going to use AI to do your case prep, it could be a valuable tool, but just look at it closely. Don't assume it's going to have everything there. And also be concerned about the privacy element. Okay, get a free case evaluation. No Sky is here. Good evening. Hello, No Sky. And No Sky sent me, speaking of AI, he sent me this really creepy thing today of a picture, my picture, animated talking in a very weird voice. And it was basically like reading an article I had written. It's really kind of scary because if you didn't look closely, you'd think it was me talking. It was like a profile. Years ago, I had this picture taken. The state bar, they don't do it anymore, but it used to be you could, they had a like Atlanta Bar Association directory. And so that you could go down to the state bar or the Atlanta Bar headquarters and they would take your picture and you could buy it. So it became like your profile, your headshot. And so I had one, wasn't the greatest picture in the world, but I had it done. Cost me $30 or something like that. So I was using it for a long time, and I still use it sometimes in like just like websites and so forth. So this guy took that picture and put it into an AI engine and had me reading. And if you looked at it, it's me, just my mouth is moving. So it doesn't look that realistic, but if you look at it, it looks like me talking. And theoretically, you could use that to make a video of somebody talking. In this one particular AI tool that we use, it'll actually, let's say that I'm reading something straight ahead, it can change where your eyes look. So it's getting really kind of crazy out there as far as what these things do. And, I think some of it can be very useful. Some of it can be creepy. And again, you got to do your due diligence to believe who to trust. And again, if somebody took my picture and put incorrect information out there, people could get fooled. I hope that doesn't happen. But, that's why, YouTube is not going to be on YouTube. It's not going to be on, on good, reliable sources. But if you happen to see me on some crazy website talking and it doesn't make sense, that could be an AI thing. So, all right. Anybody can approve currently? Yeah, I mean, people can approve. Like I said, I had 5 approvals and 6 hearings this past week. So, yeah. They are getting approved, but it is slow. Guitar, talks about what Congress is giving themselves pay raises and we're not working. And I'm not going to argue with you. Stage 4, I'm not a big believer in the whole stage 4 nonsense thing. I think it's just they're telling you something, but there's no official stage 3 or 4. Okay, Christina, I thought we're going to miss you today, but we did not. Hello, hey, Christina's here almost every week. One of my loyal visitors. I include neurologist reports from 2006. Trigeminal neuralgia 15 times a month were present with excessive absences, older now, conditions worse. That'll help you. I mean, I will tell you, I've had some difficulty with trigeminal neuralgia. It's kind of a nerve in the face that gets inflamed and it can be incredibly painful. I don't know that judges buy it. I just have not had a lot of luck with it. Just maybe it's me. I don't know. Okay, 49-year-old Matt has severe lower back pain. I will tell you, Matt, it'll be stronger when you're 50 and even stronger in 55. I don't care how strong the case is. You're 49, it's going to be an uphill battle. If you could continue working until 50 or have an onset at 50, your case will be stronger, even with an EMG and an MRI. Teresa, let's see. 51, chronic back problems, multiple MRI. 25%. So the doctor says you'd be off task 25%. You are working 18 hours. Again, how much are you earning? Are you over SGA? That's really the big question. That's going to be a big question. Because if you're over 1620 a month or SGA, that's problematic. There will be people mad that if Social Security runs out of money. I don't think it's going to happen. Oh, Sharon. Okay, well, you're the one, so you got approved without going to the hearing. We had your case. Basically, Yes, I have not been paid on you either. So we still, I think the judge issued an approval. We got the approval. That's the one where the day before the hearing, I got a call from the judge's office saying, you're going to be approved. We didn't have to go through our hearing. I will have somebody check on that. Okay. Because I ain't gotten paid, you ain't gotten paid. And this is probably just more of a, just backlog in terms of processing. But, Jen, if you're still on here, we need to check on this. But yeah, I've not gotten paid either. So it's just being held up by just the bureaucracy. Okay. Yeah, I think that's exactly right. Medication side effects, that will be very helpful. You, Harold, thank you. I appreciate that very, very much. That was very generous of you. Much appreciated. And, it will go to the Buy My Son Lunch Fund because he does my videos for me. And he will appreciate, we'll go to East 48th and he'll get himself probably a chicken salad sandwich and he will appreciate that. So I will let him know that you were the source of it. Okay. Yeah, I think as long as you're below SGA, Teresa, you should be fine. Deb says, thank you for helping me and my son. Yes, my son he's in his 30s, so he's not exactly a young kid. He has got a full-time job, and he does my videos, does a nice job with them. And he's a project manager for a big software company. And so he's really organized, which is, actually a nice thing because he's gotten much more organized as he's gotten older, and he has a big spreadsheet with all the videos on them, and so I can put the titles in, and we get them produced, and so it's really kept things rolling. Thank you, Harold. Appreciate that very much. Okay, I think Precious, I've already answered that. The best advice I can give you. Yeah, I think when waiting approval, study your medical reports. I'll tell you something else. What I would tell everybody to do. We got about 5 minutes left here. After your hearing, ask your attorney to download the audio. If you had a hearing, ask the audio and listen to it. And just listen to it so and that may be a place where, as Sharon suggested, you upload it to an AI engine and have a summary done. But listen to it. You will be amazed what you hear on that audio. Because people, you forget. You're in the middle of it, you just forget. Does alpha thalassemia, if you have symptoms? Yes, it very well could, if you have significant symptoms. Absolutely. Search with low approval when take jobs. Yeah, I maybe that's a little harsh, but I just think some of these judges don't seem to understand that their job is to, look at people and say, okay, is this person are they struggling? Is this real? And I had a buddy of mine post this, Chad Brown, put it on his website, or maybe did a video about this actually, I think. And he's like, some judges go into the hearing with the idea that they're looking for reasons to approve. They believe everybody who's applied has a sincere belief they're disabled. Then you have some judges who are truly neutral. They just want to hear the evidence. And you got some judges who assume everybody's lying and prove me otherwise. And that attitude can make a big difference. And yeah, why are they judges? I absolutely. Alicia, don't be terrified. Do not be terrified. Nothing to be terrified about. Let me just see. I think we already checked on this one. Don't be terrified. I've won cases with judges, and no matter how low the approval rate is, and you got no choice. You got to move forward with it. Got to move forward with it. So we'll have to see what your judge is, but I think you just have to move forward with it. Raghav Kotval. I have not. Let me see if it shows up. 56%. Good. That's very good. That's great. You're in good shape. Okay. And the other thing is I've had situations like one recently where a very low approval judge retired right before my hearing. I got a great judge after that. Or they assigned a new judge at the last minute. That can happen too. So you never know. You never know. But KU Thunder says it is a lottery. Yeah, that's it's very, very unpleasant in that regard. Precious says thank you. Yes, severe depression says Salim. Concentrate. I'm 55 now. Well, if you got medical support, that would be very, very helpful. We're going to run through some of these because we're getting close to the end. Beautiful world. I'm 59 years old. I have a cervical spine joint surgery when I was 722 and have chronic pain. That shows sort of a long progression of scar tissue and other complications, arthritis accumulation that can be helpful. I think being 59 makes the big difference there. Yeah, looked at the two of 2024. Yep. I think you just have to just look at and just see what the judge says. Let's see if I have it here. Now, see, I'm looking at your judge, Alicia. It's 53%. Okay, 53%. I can live with. That's fine. We're in good shape there. Okay. Yes, Charity, just email me directly, ssdanswers123@gmail, or use the form and just say that you were from the live stream. But yeah, Alicia, you're fine. You're fine. A couple more questions here. Look here. Yeah, just email me. I don't want to. We can answer that if you email me directly. Okay, you're talking about me. Yes, we do. Thank you. Why you have to claim the fee? You should not have to claim that fee on taxes as income. I'm claiming it as income. You should not. You should only be paying taxes on the percentage of the fee or the back benefit you got paid. I thought I had sent you something from the listserv about that, but you should not be paying taxes on money you didn't receive. Absolutely not. Okay. Let's see. We've got a couple more questions here. How's the rate of approval after all administrative changes in your personal or peers? If you're asking generally, any step, generally speaking, at initial, it's about 35%, recon about 15%, hearing about 48, 49%. It was higher at one point, then it went lower. About 15 years ago, it was in the 60s, went lower after the Eric Kahn debacle, and then now it's been gradually moving up a little bit. I think it's probably at a rate that's fairly reasonable. It was down in the low 40s about 5, 6, 7 years ago. So anything close to 50% in hearing, I can live with. So I think that's kind of where it's at right now. Let's hit the like button, says Luke. Absolutely. Please hit the like button. And, please leave me a favorable review. Just look me up. Go to jonathanginsburg.com and leave me a review. There's a link there. That would be great. And you can't record your hearing. There will be a recording of the hearing, and your attorney or representative can get that for you. Recon and appeals to the step 2 non-medical disability cases. Yeah, you're going to get some. I've got a couple like that where you're getting conflicting information. I can't really answer because I don't know the details, but I've had that happen to me too. What top 3 questions? I would say, what is your theory of the case? Are you basing it on listing, grid rule, functional capacity? What are the main impairments that you see as being disabling? After reviewing my file, what's the strongest evidence you've got? And what questions am I going to be asked? Those are the questions I would ask your attorney. Okay. In 2025, I'm not sure if I quite understand. We're going to be talking, so you can ask me then. After all administrative changes in any step. I think in 25, I've not noticed any real change this year from last year. It's still holding pretty steady. The time frames have been getting longer, but the actual approval rates are still pretty. Honestly, I'm pretty selective with my cases. I'm getting a lot of approvals. I mean, these cases are getting approved. Not all of them. I mean, because I got some bad, or I shouldn't say bad judges, low approval judges, but you know, the cases that mostly should be approved are getting approved. So I'm not seeing any change there. Okay. I am going to make this the last question here. Looney Tune Baboon. I'm not sure. Looney Tune on the Baboon. Okay. I got denied twice after multiple back surgery. I have another one scheduled in the future. Spinal stenosis and my whole life robbed from me. I can't run, jump, even hold my kids. Again, have you gone to a hearing yet? If not, that would be the next step. Don't take it personally if you get denied at initial or recon. That's a fairly common thing. Your age, if you're saying holding my kids suggests to me you're in your maybe 30s or 40s, that could be an issue here too. It's evidentiary driven, and you got to have really strong evidence. The younger you are, the more evidence you got to have. It's just the simple fact of it. So, okay. We are at 2 hours and 6 minutes, so I'm going to sign off now. I appreciate everybody attending. Again, if you found this helpful, leave me a review. Really appreciate that. And until next week, and it's possible I may move to 9 o'clock. I'll let everybody know. You'll see on the notice, just because it's staying late a little bit lighter, light a little bit later. And, I've been actually, to be truthful, took my wife and daughter. We played some tennis tonight, and so they wanted me to stay a little later. I couldn't do it, so I may be going to 9 o'clock. Plus, I'm getting more people on the West Coast, and it's hard for them to get on as early. I'll let everybody know, but if I do, it'll either be 8:30 or 9 next week. But I'll put notice out early, and again, we'll have some interesting guests coming up. Thanks everybody for your attendance, and we'll see you next week.